Welcome to the Supreme Court of the United Kingdom, where we are hearing the appeal in the case of Z and Hackney London Borough Council. We're currently hearing submissions on behalf of the second respondent, the Agudas Israel Housing Association, presented by their counsel, Mr. Sam Grodzinski, Queen's Counsel. Mr. Grodzinski.
My lords, my lady, for all the reasons I've already given, we submit that this appeal should be dismissed, irrespective of whether the Race Directive or Article 14 are engaged in this case. But can I turn finally to deal with those issues in any event, subject to the procedural matter that my Lord Reid, together with the other members of the court, decided earlier. In our submission, there is no direct or indirect discrimination on the ground of race, whether in the sense of matrilineal ethnicity or otherwise. Can I start with three brief references to the evidence? The first is at EF 1451. This is within the first witness statement of Mrs. Simons at paragraph 9. The claimants have taken issue with the word primarily included in the objects clause. They contend that Agudas solely provides accommodation to members of the OJC. However, all that primarily means in the rules is that Agudas puts the OJC first. While the rules allow us to assist other people, they require us to put the OJC first. In practice, this means that unless we had surplus housing or other resources which we consider were not otherwise needed, we are required to offer that housing or those resources first and foremost to the OJC. This is our primary objective, and it follows that it's restrictive. It doesn't mean that it's in conflict with our general object to benefit the community at large. Even though we may have insufficient resources to assist people from the wider community, the fact that we assist members of the OJC who are in need of housing, are poor, or are otherwise in necessitous circumstances is of itself of benefit to the wider community, because it alleviates problems which would otherwise be a burden on the wider community. And then turning forward, please, to EF 1504. This is the second witness statement of Mrs. Simons. Picking it up at paragraph 26 at the bottom of the page. Clause 1.3.2 of the policy confirms and reiterates our charitable objects. Our primary aim is to house members of the OJC. As I stated in my first witness statement, if Agudas had a surplus of housing, we would accept and house people from a non-Orthodox Jewish background. In practice, this has never happened because of the huge demand from the OJC for our homes. There are over 700 people on our current waiting list, and given our average of less than 14 social housing lettings annually across the London boroughs, it would take us over 50 years to meet our current demand. Our recent survey revealed that another 500 families in desperate need of social housing, if these were added to our list, it would take us another 35 years to meet demand. And then paragraph 28, most relevantly for present purposes. Although I explained this in my first witness statement, I would like to reiterate that we do not discriminate according to ethnic background. Our housing applicants come from a variety of ethnic backgrounds. Our sole criterion is that the applicants are of Orthodox Jewish faith. This is certainly not an issue of race. It is purely about religious observance. We respond to people from many ethnic backgrounds. The common factor is a commitment to the Orthodox Jewish way of life. And then please, EF 1479. This is in the housing application form, which applicants for Agudas housing have to complete. EF 1479, box 4, would you describe yourself as Orthodox Jewish, strictly observant of Shabbat and Kashrut? Over the page 1481, EF 1481, I showed you this in opening. In order to ensure the association's continued development of its declared equal opportunities policy, all applicants are asked to complete the following details. This information, which is solely used for monitoring purposes, is to ensure that we treat all applicants equally and fairly, irrespective of their race or colour. ethnic or national origins will not affect the outcome of your application. Mrs. Simon's evidence on this point was not challenged and was accepted by the Divisional Court at paragraphs 85 to 86. Can I, with that factual background in mind, turn to the JFS case, EF 2690. As the court will recall, that case concerns the admissions criterion used by JFS to decide who was Jewish and thus who could be admitted to the school. Unlike the present case, it did not depend at all on the religious observance of the child, as I will show you in a moment, but simply on what the court found to be the ethnic test of matrilineal descent. Can I start, please, with Lord Phillips at paragraph 13, EF 2708. Just below letter A in the second line on that page. In deciding what were the grounds for discrimination, it is necessary to address simply the question of the factual criteria that determined the decision made by the discriminator. And then at EF 2716, paragraph 46, between letters G and H, discrimination against a person on the grounds that he or she is or is not a member of either group is racial discrimination. JFS discriminates in its admission requirements on the sole basis of genetic descent by the maternal line from a woman who is Jewish, in the Mangla as well as the religious sense. I can see no escape from the conclusion that this is direct racial discrimination. And then finally, Baroness Hale, please, at EF 2722, paragraph 66. So at long last, I arrive at what, in my view, is the only question in this case. Is the criterion adopted by the chief rabbi, and thus without question by the school, based upon the child's ethnic origins? Then picking it up in the last 3 lines of that page. But it was because his mother was not descended in the matrilineal line from the original Jewish people that he was rejected. This was because of his lack of descent from a particular ethnic group. In this respect, there can be no doubt that his ethnic origins were different from those of the pupils who were admitted. It was not because of his religious beliefs. The school was completely indifferent to these. They admit pupils who practice all denominations of Judaism, or none at all, or even other religions entirely, as long as they are halakhically Jewish, descended from the original Jewish people in the matrilineal line. In our respectful submission, the position could not be more different in this case, and there is no direct discrimination on the ground of ethnicity. As to indirect discrimination, the most relevant authority is the recent Court of Justice decision in the Jaiska Finance case, Authorities 34, EF 3334. Can I show you the headnote, just to give you an understanding of the facts? It's the first lines of the headnote between letters D and E on 3334. The complainant, born in Bosnia-Herzegovina, lived in Denmark and had acquired Danish nationality. He and his partner, a Danish citizen born in Denmark, purchased a second-hand car, partly financed by a loan granted by a credit institution. Before making the loan, the credit institution, having established that according to the information on his driving license he'd been born outside the EU, requested additional proof of identity in the form of a copy of his passport or residence permit. And the question ultimately considered by the court was whether that was direct or indirect discrimination on the ground of ethnicity, to which the court answered no. And for reasons I'm going to show you, the decision of the court makes clear that in order to establish indirect discrimination on the ground of ethnicity, the relevant practice has to put persons of a particular ethnic origin at a disadvantage compared to others, and that it will not be sufficient if the disadvantage affects everybody other than the advantaged group in an undifferentiated way, i.e. irrespective of particular ethnic origin. Can I take you first, please, to the opinion of the Advocate General Val, starting at EF 3334. No, I beg 3344. Picking it up under question 3, just above or at paragraph 57. In order for a measure to be capable of falling within Article 22b, that's the indirect discrimination article, it's sufficient that although using neutral criteria not based on ethnicity, the measure has the effect of placing particularly persons of a certain ethnic origin at a disadvantage. See the Bulgaria case. Paragraph 58. When considering whether Giska Finance's use of the neutral criterion of place of birth entails indirect discrimination, it could be claimed that targeting persons born outside of the Union or EFTA states is more likely generally to affect persons of a certain ethnic origin adversely. Indeed, that's the essential view of the Kingdom of Denmark, which considers that the additional requirement imposed by the practice at issue affects persons born in third countries and consequently mainly persons of a non-Danish ethnic origin. However, such a view is unsustainable. Assuming for the sake of argument that the Kingdom of Denmark is correct to claim that persons not born in that member state are not generally of Danish ethnic origin, that's not sufficient for a finding of indirect discrimination. Indeed, in order to be operative, the concept of indirect discrimination under that provision requires that the alleged discriminatory measure has the effect of placing a particular ethnic origin at a disadvantage. Put differently, that provision requires identifying the particular ethnic origin or origins to which the protection under that directive applies and which has suffered a less advantageous treatment. Unlike the view expressed by the Kingdom of Denmark, that provision cannot be understood to confer negative protection against measures which arguably place a given ethnic origin at an advantage without also identifying a specific ethnic origin which is put at a disadvantage. And then that's fleshed out in the following paragraphs. At paragraph 61, to be sure, the triggering of the prohibition on discrimination on the ground of ethnic origin requires neither the person concerned actually to belong to the ethnic community which is the target of the less favourable treatment, that's the Bulgaria case, nor a victim to be positively identified. Yet that does not alter the fact that Article 22b requires the identification of a particular ethnic origin targeted by a discriminatory measure. The court's case law confirms that. That all is then echoed and agreed with in the court's judgment, picking it up, please, at EF 3356. At 3356, from paragraphs 17, in fact, it starts at paragraph 16 on the previous page, 17 through to 25, the court rejects the argument that there was direct discrimination. I won't take up time looking at it now, but everything said there reinforces our submission based on the JFS case that there was no direct discrimination in this case. And then indirect discrimination is addressed from paragraph 26 and following. With regard in the second place to whether such a practice constitutes indirect discrimination, it's necessary to determine whether in light of Article 22b, that practice, although on the face of it neutral, would put persons of a given racial or ethnic origin at a particular disadvantage compared with others. The word particular disadvantage in that provision must be understood as meaning that it's particularly persons of a given ethnic origin who are at a disadvantage because of the measure in issue. In that connection, it was argued before the court that whatever the less favourably treated ethnic origin of Mr. Huskic, persons of Danish ethnicity will be treated more favourably as a result of the practice at issue. However, it is sufficient to note that that requirement is applicable without distinction to all persons born outside the territory of a member state of the EU or EFTA. It should be noted that indirect discrimination is liable to arise where a national measure formulated in neutral terms works to the disadvantage of far more persons possessing the protected characteristics than persons not possessing it. Nonetheless, the concept of indirect discrimination is applicable only if the allegedly discriminatory measure has the effect of placing a person of a particular ethnic origin at a disadvantage. As the Advocate General observed, for the purpose of ascertaining whether a person has been subject to unfavourable treatment, it's necessary to carry out not a general abstract comparison, but a specific concrete comparison in light of the favourable treatment in question. It follows that the argument that the use of the neutral citation at issue, namely a person's country of birth, is generally more likely to affect persons of a given ethnicity than other persons can't be accepted. In our respectful submission, that is exactly the position here. It is true that Agudas's policy indirectly affects everybody who is not halachically, matrilineally Jewish, but it affects the excluded class in an entirely undifferentiated manner, whether you are of Chinese ethnicity, Afro-Caribbean ethnicity, white Anglo-Saxon ethnicity, or otherwise. For that reason, my lords, my lady, we do not accept there is any indirect discrimination in this case. Can I then finally deal with Mr. Wise's alternative case based upon Article 14, for which he must establish that Agudas's policy falls within the ambit of Article 8. That issue was addressed by the Court of Appeal at paragraphs 47 to 50 at EF 238. And I don't intend to take up time in reading out the relevant paragraphs 47 to 50. And with respect, we entirely endorse the Court of Appeal's reasoning there, including its reliance, its correct reliance, on the earlier decision of the Court of Appeal in the H and Ealing case. Instead of taking up time by doing that, I just want to emphasize 3 points. First, we are in the present case concerned with a transfer of the applicants from one property to another. There is no Strasbourg or domestic case law supporting a conclusion that such a transfer under a housing allocation scheme will in principle come within the ambit of Article 8. Mr. Wise has not identified any such authority, and for the reasons given by Lord Justice Lewison in the Court of Appeal below, echoing the Ealing decision of the Court of Appeal, there is no principled reason to extend it that far. That's my first point. My second point is to address Mr. Wise's written case at paragraph 48, where he seeks to say that on the special facts of this case, they do fall within the ambit of Article 8. EF 125, please. This is paragraph 48 of the foot of EF 125. This is where the appellant submits that the analysis in the Ealing case and in the Court of Appeal in this case was wrong in principle and on the facts. He says there's no principled basis for holding that the ambit of Article 8 encompasses a situation in which the applicant is not currently housed, but doesn't encompass a situation in which the applicant is living in temporary accommodation that is unsuitable, brackets, indeed dangerous and precarious. But I have already shown, my lords and my lady, in my opening factual submissions, why that is factually incorrect, and why by the time the appellants started this judicial review claim against my clients, they were no longer in any dangerous or precarious property. And the reference, again, I'm not going to go back to it, is EF 779, paragraphs 8 and 9. My final point is that in our submission, the Article 8 link becomes even more tenuous, and the tenuous connection is not enough, even more tenuous when one recalls that Agudas only controlled 1% of the social housing estate in Hackney, the remaining 99% being potentially available. Thus, at the most, this was a case about the appellant having to wait somewhat longer than they otherwise would have done until a suitable property became available. And my lords and my lady will recall that between the time of the divisional court and the time of the Court of Appeal, it is common ground that they were rehoused in what they accept to have been suitable accommodation. So this was not even a case about a basic entitlement to be moved at all. At highest, it was about them having to wait a few months longer to be moved. So for all those reasons, we submit it does not matter. This case does not fall within the ambit of Article 8 for the purposes of engaging Article 14. My lords and my lady may decide it is not necessary to decide that issue for the purposes of disposing of this appeal. Can I, in that final context, just invite you to consider one very recent observation in the latest decision of the Court of Appeal in this area, the JCWI case. It's at Authorities 57 EF 3978. This is in the judgment of Lord Justice Hickenbottom. If you could start, please, at EF 4012. Where, with respect, Lord Justice Hickenbottom engages in a helpful analysis of the ambit question, starting at paragraph 97. And he traverses the Strasbourg and domestic authorities all the way from 97 through to 111. Can I just pick it up, please, at 105, where he, with respect, accurately says that the authorities that bear upon the ambit of Article 8 in the context of housing cases do not suggest any clear or consistent approach. Does my lords and my ladies see that? And then over the page, paragraph 109, he says in Ward and Hillingdon, where the issue arose again, although it proved not to be determinative, a different constitution of this court considered the question of the required link with Article 8 in cases involving accommodation best left to a case in which it matters. I respectfully agree. And we would also respectfully agree and sound at least a polite word of caution about deciding a case on the ambit of Article 8 unless my lords and my lady consider it to be determinative in this appeal, which for all the reasons we've given it should not be. And then in the last 2 or 3 minutes, can I just deal very briefly with the question of remedies, if one ever gets there? Insofar as it is necessary to make this submission, we do submit that reading in an additional proportionality test into section 193(2)(b) would not be possible under section 3 of the Human Rights Act, notwithstanding the admitted strength of that interpretative obligation as explained in the leading case of Gaydan and the cases which follow. And that is so for all the reasons pithily given by the Court of Appeal at paragraph 53 EF 239, which I don't intend to go back to. Likewise, as to EU law, we again submit that notwithstanding the strength of the leasing obligation, such a reading would not be possible. In summary, it would go against the grain of the expressly bifurcated alternative limb approach in 193(2). My lords, my lady, those are our submissions.
Just on that last point, if we were to get that far, the consequence then presumably would be that we would, under the Human Rights Act, be able to make a declaration that 1932B was incompatible with the convention right.
Well, my lord, we've taken a procedural point on this in our written case, because had that been...
Well, yes, of course, it would have to be intimated to the Secretary of State.
And it never has been. And Mr. Wise said yesterday, in fairness to him, that he was not seeking the declaration of incompatibility. How he squares that with his submission under EU law that you should disapply 1932b, I'm not entirely sure.
Yes, yes, and for sake of completeness, that would be the consequence if 1932b couldn't be, was ex hypothesi inconsistent with community law, with EU law, and couldn't be leased into conformity.
My lord, yes.
Yeah, yeah.
But it won't come as a surprise that I will close by saying that we don't get that far.
No. Well, thank you very much, Mr. Godzinski. Mr. Hutchings.
My lord, my lady, I intend to restrict my submissions in the time I have available to issue 3, apart from a few introductory points. I just had one reference for your lordships and your ladyship in relation to the factual background, which is relevant to whether or not this case falls within the ambit of Article 8. And that is that you were taken to the order made in August 2017 at page 801, but not taken in the previous proceedings between the appellant and the first respondent, Hackney. But you weren't taken to the second order that was made in October 2017. For your notes, it's at page 802, and it contains an agreed recital that by that date, the appellant and her household had been rehoused safely.
Yeah.
So, in relation to, in our written case, we've made submissions on issues 3 and 4. And our written case in relation to issue 4 is at EF pages 168 and 174. And I'm simply going to rely on it with just a very brief summary, which is the divisional court found that Agudis's allocation policy was a proportionate means of addressing the disadvantages and particular needs of the Orthodox Jewish community. And one should remember that the appellant's case before the divisional court was that the OJC was not in any disadvantageous position, did not have any special needs in relation to housing. And that was squarely addressed and rejected by the divisional court. It begins the paragraph 59 in the section which is headed the claimant's submissions on section 158. And you've been referred to the relevant sections, but if one looks at paragraph 59 following, squarely the appellant's case that the relevant group was not at a disadvantage. And when one looks at the various findings, it should always be recalled those were findings of relative disadvantage of the OJC. So in reaching the conclusion that it was proportionate, in my submission, the divisional court applied the correct proportionality test. Before them, the test to be applied was common ground. But in any event, there was no error of principle or flaw in their logic, such to render their assessment wrong, which is the relevant test for this court. So that's all I intend to say orally about issue 4. I just wanted to say a word about why we are here, that is to say Hackney. So in the proceedings below, there was a separate challenge against Hackney's nomination arrangements with Agudis, and it failed before the divisional court and the Court of Appeal, and permission to appeal to this court on what would have been ground 5 was refused. There is therefore no subsisting challenge to anything that Hackney did or failed to do. And although Hackney is named as first respondent to this appeal and so served, we've given careful consideration to the question of whether or not to participate actively in this appeal. We do so for two reasons. First, in Hackney's view, Agudis makes a significant contribution towards improving the housing conditions of a particularly needy minority group within Hackney's area. That's the first reason. The second reason is this. If the appellant's submissions in relation to issue 3 were accepted by this court, positive action under section 158 is effectively neutralised. The section is, in effect, eviscerated. And that would be a regressive development in the law, which would set back the advancement of equality. I just wanted to say something general about the question, what is positive action? And classically, it is direct discrimination that is justified. I'm sure your lordships and your lordship will look at this in various ways. An easy way to do so is by reference to sections 13 and 158. I don't suggest you turn them up now because I just want to have an overview, but they're at electronic pages 2348 and 2355. So the definition of direct discrimination in section 13 of the Equality Act 2010 is in essence that A treats B less favourably than others because of a protected characteristic. Here we might say because of the lack of a protected characteristic. But under section 158, subsections 1 to 2, that may be justified. Direct discrimination may be justified if it is a proportionate means to overcome a disadvantage or to meet needs of persons who share that protected characteristic. So the essence of positive action is formal inequality, which is justified because it promotes substantive equality. And a further point to note, because this is essential to the nature of positive action, is that formal inequality operates at the individual level, whereas the justification of positive action operates at the group level. And you will see that when you look at section 158, 1 to 2. It's also referred to in Fredman, which was the academic text with which you were provided separately. At page 232, you were referred to the opening comment in that chapter that positive action was a troublesome concept. But then it goes on to say that the nature of it is that discrimination is justified by reference to substantive equality, subject normally to a test of proportionality. So what I've said about the nature of positive action is consistent with that text. I wanted also to provide a more everyday example of positive action which was relevant to local authorities. Now, local authorities have allocation schemes like Hackney's housing allocation scheme in this case, which contains the rules for allocating social housing. Those schemes commonly provide for a residence condition. That is to say, if you have not been resident in the local authority's area for, say, 5 years, an applicant is not eligible, technically in the statutory language, qualified to join the housing register, and usually that is subject to exceptions. It has been held by the courts in a case that my learned friend Mr. Wise QC was involved, and to which you've just seen reference, the case of the Crown on the application of Ward against Hillingdon, London Borough Council. I'll give you the reference. You don't need to look at it, but I'll give it to you just in case. 2019 PTSR 1738. So in that case, it was held that such a residence condition amounted to indirect discrimination against Irish travellers who would find it harder to meet the residence condition due to their nomadic culture. And the same, I would submit, would be true of Romany gypsies. So how does a local housing authority address such a situation? Well, the obvious solution would, to cure the indirect discrimination, would be to introduce exceptions to the residence condition for Irish travellers and Romany gypsies. And that is, in my submission, a paradigm situation where formal discrimination is permissible because it promotes substantive equality of treatment. There's a certain affinity with the burial case, which you have at page 2621, but I won't go develop that submission, just give you that reference. But on the appellant's case as to the scope of permissible positive action, the solution I've suggested that a local authority might wish to adopt cannot be done. It's not a tie break. It's consists in introducing rules which discriminate directly on the basis of race and so forth. So I now want to move on to issue 3, which is the substance of my oral submissions, and just provide a brief logical summary of the landscape. My first point is that in respect of recruitment or promotion of employees, the CJEU case law says that direct discrimination on the basis of sex is impermissible. That is its broad effect. My second point is any positive action within that context is highly circumscribed if indeed, on a true analysis, positive action is permitted at all. It amounts to a defeasible tie-break, and as we will see shortly, it is justified on the basis that a prima facie rule to favour a woman candidate who is equally qualified may combat prejudice, in other words, covert direct discrimination in favour of men. In other words, the way in which the CJEU has approached positive action in the context of recruitment decisions is that there really is no exception to the rule banning direct discrimination. If there is one, it is entirely minor. My third point is that when we look at the, and I'm sure you'll look carefully at the case law yourselves, but you'll see that the CJEU justifies this approach in relation to the concept of equal opportunity. And it says that any direct discrimination on the basis of sex when it comes to giving someone a job goes beyond equality of opportunity. And that is equality of opportunity in the restrictive sense of a job being given to the best candidate on the day. So my fourth point is just to look for a moment at the concept of equality of opportunity. Primary content of the concept of equality of opportunity as we know it is an absence of direct discrimination in relation to recruitment. It is open competition without discrimination. It is, however, consistent with positive action in relation to some of the surrounding conditions which give rise to disadvantages for certain groups on the labour market. So the classic examples are things like access to training or childcare, particularly for women. But the use of direct discrimination, even in the context of positive action, in the context of recruitment decisions, is a particularly troublesome concept in that context, and especially when, as all the economies of the EU states and indeed our own are based on a free market. And that's my fifth point, that the EU is founded on the principle of a free market. So unrestricted competition in the labour market goes to the heart of one of the principles of the single market, that is the free movement of labour. My sixth point is that in other contexts, equality of opportunity has no relevance. So, for example, in relation to the allocation of welfare benefits, no one would normally think that equality of opportunity was a concept that had any bearing at all. What we're looking for is a fair allocation of state resources to those who need it most. And my seventh point is that that is reflected in the CJEU case law. There isn't much case law on positive action outside of the specific context of recruitment in an employment sense. But what there is simply applies a normal proportionality test. And the restrictive approach that we see in relation to recruitment is not repeated. It does not extend generally across all the CJEU case law on positive action. And my eighth point is that that distinction is reflected, as you've been shown, in the Equality Act, sections 158 and 159. That within section 159, subsection 4, there is a clear restriction on the scope of positive action in respect of action within subsection 3, that is to say, recruitment and promotion. It is not repeated in relation to positive action generally under section 158. And I also noted, while my learned friend Mr. Grzyński was making his submissions, the same is true in respect of section 193, because of section 1939A, which exempts section 39 of the Equality Act 2010 from the application of section 193, the charities exception. And just to tell you what that is, section 39 of the Equality Act 2010 is to employers what section 29 is to service providers. In other words, it's the provision which actually imposes the obligations not to discriminate, etc. So the references to all that, which I'm sure you'll look at later, are 2359 to 2363. So I wanted to move straight to the, if I may, to the CJEU case law about recruitment and promotion, starting with Kalanki, which is at page 3359. Now, this case concerned a tie-break in favour of women in the context of recruitment promotion in the public service, where women were underrepresented in the relevant category. For your note, I don't propose to turn up now, at page 3361, the Attorney General Tesoro, paragraphs 1 to 3, contain a nice summary of the issue. The Equal Treatment Directive, which you've already looked at, Article 2124, and the Landesgleichstellungsgesetz, which was the national law. What I would like to look at briefly, if I may, is paragraph 9 on page 3365. So this is where the Advocate General sets out a distinction between different types of positive action. In summary, 1, removing disadvantages, 2, more equal division of family responsibilities, and then 3, the troublesome one, which is quotas or aims in relation to recruitment. So the first 2 are dealt with in 9. It may be, well, actually, all in 9, the first paragraph of 9. It may be easier if you just have a quick read of paragraph 9. And it's simply helpful to have that under one's belt when one looks at the case law in general, because this distinction between different types of potential positive action in the context of recruitment are referred back to at various times. And in terms of quotas or goals for actual recruitment, it's often talked about that being a potential remedy for historical or structural discrimination is how it's often referred to. Paragraph 10 is relevant in that the Advocate General recognises that the quota in the instant case was not strict. It's actually a tie-break provision. But over the page, 3366, it's only too obvious that even in this case, there is discrimination on the grounds of sex. And then I believe you would take into the analysis of paragraphs 11 to 13, culminating in the conclusion, page 3367, the paragraph which begins opposite letter C on that page. So that the national legislation at issue in this case is not designed to guarantee equality as regards starting points. By giving priority to women, the national legislation at issue therefore aims to achieve equality as regards the result, or better, fair job distribution, simply in numerical terms between men and women. This does not seem to me to fall within either the scope or the rationale of Article 2.4 of the directive. And I believe you were taken to that before, and Lord Reid in particular commented that that referred to equality of opportunity. There is then, and that's the crucial conclusion, there is then, the Advocate General goes on to consider the 3 possible types of, or his as it were, categorization of positive action. But then for your note at 3369 at paragraph 19, he simply comes to the same conclusion, that it's not permissible because it goes beyond promoting equality of opportunity. In terms of any of this being relating to proportionality, the only reference to proportionality is 3372 paragraph 25. The measure in question is disproportionate in relation to the aim pursued, or in any event pursuable under Article 2.4. Well, that's unsurprising, because what the Advocate General has advised is that the measure in question goes beyond promoting equality of opportunity, and it actually gives a job to a woman because of her sex. And that's not a pursuable aim. And then the judgment begins at 3373. It is relevant to look 3374 paragraph 7, a feature of national law it's paragraph 9. The Grundgesetz would require the national law to make exceptions in appropriate cases. And it's important to appreciate when one looks at this case law, and in particular, the use of the phrase that we're going to see in a moment, absolute and unconditional priority, that in this case, the national law was both qualified and conditional. So we then see at 3376, the conclusions of the court expressed shortly, paragraphs 22 to 23 is the essence of it. So agreeing with the Advocate General that the national rule oversteps the limits of Article 2.4 of the Equal Treatment Directive. And it substitutes for equality of opportunity the result. What one sees at paragraph 22, and I believe my own friend Mr. Grzyński referred you to it, is the first use, so far as we're aware, of the term absolute and unconditional priority. That seems to mean an appointment on the ground of sex. Because, as I've pointed out, on the facts of the case, the national law was both qualified and conditional. The next case is, chronologically, is Marshall, which is at 3410. And that was, in essence, the same question as in Kalanki. The only difference in the national legislation was that the tie-break in favour of a woman candidate was defeasible. That is to say, it applied unless reasons specific to an individual candidate tilt the balance in his favour. So for your notes, when you're looking through it, again, the Advocate General 3412, paragraphs 1, 6 and 11, a convenient summary of the issue, paragraph 6, the national law, and paragraph 11, the question, conformity with the Equal Treatment Directive. And again, 3416 is a convenient summary of the rival submissions, paragraphs 25 and 26. In essence, different governments submitting either that Kalanki applied or that Kalanki should be distinguished. At 3418, paragraph 28, there's a pertinent observation with which we can agree that the national rule in Kalanki was not in fact absolute and unconditional in the ordinary sense of the word. And there's a reference there to the courts in Kalanki having recognised that the rule was subject to exceptions, as I showed you. 3420, there is also a relevant observation at paragraph 34 that if an exception clause doesn't actually stop a rule having a discriminatory effect. And this is particularly relevant to the kind of the drift that's sought to be suggested from this line of case law in the CJEU, and the suggestion that somehow if Agudis had an allocation policy that was more like Bangla Housing Association, that would comply with this line of CJEU case law. It would not, if this line of case law applied to it. So why did the court reach an opposite conclusion in this case? Because the Advocate General decided that the national law was not permissible and it was ruled to be unlawful in accordance with Kalanki. In my submission, the court didn't disagree in relation to the principles, but as to their application to the facts of the case. And the judgment begins at 3426. The crucial part is 3429 onwards. The essential reasoning at paragraph 29 on 3429 is that this tie-break is permissible because it's aiming at counteracting prejudices which favour giving the job to a man. In other words, it aims to address covert, direct discrimination in favour of men. So there is, in some, no or at the most very little direct discrimination at all in favour of women in this case. And therefore, paragraph 32, we see the court referring to the Kalanki decision and the fact that it would not be permissible to have an absolute and unconditional priority for women without going beyond the limits of the exception. But then saying at paragraph 33 that the rule in this case did not offend Kalanki because there was an objective assessment of male candidates, and if they're better than the female candidate, that overrides the, as it were, default rule. In other words, the objective assessment means there's no direct discrimination at all. And that's why I say, when one looks carefully at Marshall, the effect of the CJU case law is that in the context of recruitment of employees or promoting employees, there is virtually no room for positive action at all. There's no room for direct discrimination. And one sees that illustrated in Abrahamson 3182. It's of interest really for two reasons. One, because it's another example of an exceptionality clause which didn't save the national legislation. But also, secondly, it postdates the Treaty of Amsterdam, and therefore it contains some very limited observations on Article 141 of the EC Treaty. And in essence, it seems that the court was reluctant to treat Article 141 as going any further than the Equal Treatment Directive. In other words, didn't go any further than permitting the promotion of equality of opportunity in this context. So 3184, there is Article 141 EC, and particularly 141.4, it's paragraph 4 of the Advocate General, with a view to ensuring full equality in practice between men and women in working life, the principle of equal treatment shall not prevent any member state from maintaining or adopting measures providing for specific advantages in order to make it easier for the underrepresented sex to pursue a vocational activity or to prevent or compensate for disadvantages in professional careers. Now, viewed through the prism of the three different types of potential positive action as identified by Advocate General Tesoro and Kalanki, one might question whether this was intended to embrace his type 3, that is to say, quotas or aims for promotion. It's a very textual approach. Not sure it's really justified in this context of EU law. We'll see what the court made of it in a moment. So paragraphs 8 and 9 of the Advocate General refer to the national law. That's 3185, 3186. And one sees the quickest way to see the exceptionality clause is at the end of paragraph 9, 3186. Positive discrimination must not, however, be applied where the difference between the candidates' qualifications is so great that such application would give rise to a breach of the requirement of objectivity in making the appointments. So it looks like a national law that's modelled on Marshall and tends to be pretty much the same. Certainly it's got an exceptionality clause in terms of the tie break in favour of women. For your notes, 3190, we've got the Advocate General, paragraph 28, referring to the well-worn formula of absolute and unconditional priority and so forth. And then also for your note, 3192, paragraph 31. The Advocate General considered the case purely in terms of the Equal Treatment Directive. The judgment begins at 3194. I am interested in the sharp end at 3203. So what we have here, paragraphs 52 to 55, is the Court of Justice saying that the legislation at issue in the main proceedings automatically grants preference to candidates belonging to the underrepresented sex. That's the tiebreak. And 53, they say the scope of the exception cannot be precisely determined. And in essence, that means that you may have a situation where a job is given to a woman based on the mere fact of belonging to the underrepresented sex. And that is so even if the merits of the candidate so selected are inferior to those of a candidate of the opposite sex. That is the very definition of direct discrimination in relation to recruitment. And the court then says such a method of selection is not such as to be permitted by Article 2.4 of the directive for the familiar reasons with which we've just seen. But then the court tantalizingly goes on to say, paragraph 54, in the circumstances it's necessary to determine whether legislation such as that at issue in the main proceedings is justified by Article 1414 EC. And the only answer we have is that at paragraph 55, page 3203. So in essence, what the court said is it cannot be inferred that Article 1414 allows a selection method of the kind at issue in the main proceedings, which appears on any view to be disproportionate to the aim pursued. So we've got no proportionality analysis. In essence, what the court says is we don't think, or we doubt, that Article 1414 goes any further than the Equal Treatment Directive, Article 2.4 in particular. And as a one-line remark, it appears to be disproportionate to the aim pursued. That rather brought to mind what Advocate General Tesoro said in Kalanki. It rather depends on which aim you're looking at. If it's the pursuable aim of equality of opportunity, then one can see what the court means. But that's all we have. So there's no great, there's no template of proportionality or anything like that. In essence, the court arrives at the conclusion that this national legislation does not pursue equality of opportunity, and therefore it is impermissible, and that is it. And Brehesh is really just the same. That's, for completeness, that's at 3206. This case concerned different age limits, the recruitment of men and women. That was the nub of it in the civil service. The Advocate General's opinion contains a lengthy discussion about a potential juridical basis for positive action, including as to results, but the judgment, which begins at page 3219, merely follows the Kalanki martial line of authority. And if we pick it up 3222, paragraph 23 is the familiar formula. Paragraph 27, the court concludes that the national law automatically and unconditionally gives priority to the candidates. In other words, there's direct discrimination on the ground of sex because of the different age limits which apply to some women. And then 28 says, it therefore follows that it cannot be allowed under Article 2.4 of the Equal Treatment Directive. That's over the page 3223. And then in relation to Article 1414 EC, we've got paragraphs 30 and 31. And in essence, paragraph 31, it's virtually identical word for word to the Abrahamson case. And that's all we have. That's really, that is it in terms of the CJEU case law. I just wanted to refer very briefly to my written case, paragraph 30 on page 162, because there when I referred to Brihesh, there's a quotation and I've given a reference paragraph 55, its impact paragraph 31, and the same applies to the footnote number 2 at the bottom of the page. That should be a reference of paragraph 31. And the submission, my submission remains that at paragraph 32 on page 163. And you were referred briefly to Craig and De Burker, and for your note, page 4820, the commentary is specifically limited to, and I quote, the field of access to employment or promotion. And that's my submission, that this line of case law is limited to that context. So I believe you were taken to Badek at 3431 before lunch. And the essential point from Badek is, I'll give you the references. So page within the judgment, which begins at 3453, at page 3455, paragraphs 7 and 9, that was the national law, the HGIG, which in essence provided that half of training places and half of interviews should go to women. And the observation I make is those were quotas. They are automatic in the wording, in the sense that the CJU uses it in the case law. They automatically and unconditionally prioritize women. But because they relate to training places and interviews, not jobs themselves, they are permissible. And the references are page 3461, paragraphs 45 to 47. The submission essentially made that training places should be treated in the same way as jobs. Rejected, page 3462, paragraphs 52 to 54. We can look at it if you would like. I know you've been there already today, but 3462. So it's paragraphs 52 to 54. And my observations are, firstly, because we've moved slightly away from the immediate context of a recruitment or promotion decision, ever so slightly really, we've moved on to a question of training places. Then this is in accordance with the restricted concept of equality of opportunity. And the considerations taken into account, paragraph 53 and 54, look very much like an ordinary proportionality analysis. So quota applies only to training places for which the state does not have a monopoly. So the training places are also available in the private sector. So no male candidates definitely excluded from training. And they're authorised and permissible. And in relation to the fourth question, that's the invitations to interview. Paragraph 59 is the submission against the rule in relation to being called to interview being permitted, because it's a strict quota. That's the submission by the land attorney, paragraph 59. And that's rejected because at paragraph 60, the court says it does not imply an attempt to achieve a final result, appointment or promotion. So once one's moved away and it's upheld as permissible, again, paragraph 61, that looks like the kind of considerations that would be relevant in an ordinary proportionality analysis. So this is the first of the cases that tends to show once one steps outside the immediate context of recruitment promotion, positive action is permitted, but subject to an ordinary proportionality test. We have further cases. We have Lommers in particular, which is at 3377. So this is the case about subsidised nursery places provided by the Ministry of Agriculture for women employees only, save in cases of emergency. If we go straight to the judgment, it begins at 3401. I'd like to pick it up at 3407. Simply invite you to read 38 and 39. And in my submission, what the Court of Justice is there saying, paragraph 38, is because this is not about places of employment which are reserved for women. In other words, a decision to appoint an employee, but it's about nursery places, working conditions designed to facilitate the pursuit of and progression in their career. That's the court's wording. It is in accordance with the principle of equality of opportunity. There we are. Yes, it forms part, so that's the beginning of paragraph 38. It forms part of the restricted concept of equality of opportunity for that reason. And then paragraph 39, I believe you looked at this morning. the court says due regard must be had to the principle of proportionality, which requires that derogations must remain within the limits of what is appropriate and necessary in order to achieve the aim in view, and that the principle of equal treatment be reconciled as far as possible with the requirements of the aim thus pursued. My submission is that is an ordinary proportionality test. Appropriate and necessary. It's the ordinary language used by the CJEU referring to a proportionality test. And it says that the principle of equality of treatment should be reconciled as far as possible with the requirements of the aim. Well, that's another way of saying that they're necessary. Because if the measure is necessary to pursue the aim, then as far as possible, it's in accordance with the rule that's being derogated from. And then 3408, I'm sure you'll take time to read paragraphs 41 to 48, which is the reasoning of the court in concluding that the measures in that case were proportionate. These are the ordinary considerations which any court would look at when deciding whether or not a measure was proportionate, appropriate and necessary. So there's the question, paragraphs 42 to 44, is it necessary to exclude men in order to achieve the aim? Well, yes, because there are women still on the waiting list for nursery places. It's also relevant that private nursery places are available to men, which obviously lessens the impact on the group adversely affected. And then paragraphs 45 to 47, is it appropriate? Yes, because places are also available to men who have sole care for children. So those are the ordinary kind of considerations one would expect to see in a proportionality analysis. And the last case I wanted to look at was the Cresco case, which is at 3278. And this was the Good Friday case, if I put it that way. The Good Friday off for members of certain Catholic churches. It's important because obviously it's a decision of the Grand Chamber. And also for our purposes, because if we look at 3321, it actually considers positive action, Article 7 of the Equality Framework Directive. So that's paragraph 6 on 3321. That's within the judgment. What we see at 3329 paragraph 65 is the Grand Chamber approving and citing in terms the proportionality test used in Lomas, paragraph 39. So that's 3329 paragraph 65. So word for word adopting the same proportionality test. And in this case, I'm happy to say there is no reference to the concept of equality of opportunity whatsoever. In my submission, because it's irrelevant when one's talking about having religious holidays off, or national legislation that provides for days off on religious holidays for employees. Equality of opportunity has got nothing to do with it. It's a benefit provided to employees, which is in the interests of promoting their religious observance or respect for their religious observance. Paragraphs 66 to 68, the court concluded that the Austrian legislation failed the proportionality test. In essence, bearing in mind that this was national legislation of general application to all employees, what the legislation purported to do was say that members of certain Catholic churches could have Good Friday off, but there was absolutely no equivalent provision for any other religion, although exactly the same logic would lead the legislation to provide for other religious holidays off for people who are observant of other religions. And in my submission, it's a classic under-inclusiveness case. It reminded me of Gaydon Mendoza, when your lordships and your ladyship will recall that the succession provisions in the Housing Act, it was the Rent Act 1977, provided for the survivor of a heterosexual couple who were not married but living together as if they were husband and wife to succeed to the tenancy. But it made no equivalent provision for the survivor of a homosexual couple. And the reference, which I won't take you to now, is paragraph 17, Lord Nichols' speech. It's at page 3692. In other words, the reasons, and what Lord Nichols said was the reasons underlying the social policy are equally applicable to a survivor of a homosexual couple. And in this case, the Cresco case, one would say the reasons underlying the social policy are equally applicable to someone who is observant of the Muslim faith. And so it's a classic under-inclusive measure. So in my submission, when one looks at Cresco, one sees the whole the Kalanke-Marshall line of authority and the concept of equality of opportunity is completely irrelevant here. It's an ordinary proportionality analysis and an unsurprising result. And indeed, one can find a direct analogy in our own case law, domestic case law, applying our own well-established proportionality template. So that the essential submission for the appellants, which is in some way there is some special proportionality test that applies in the CJEU case law when it comes to positive action, is simply wrong. And in my submission, the best, and particularly here, one bears in mind, this case is in essence a kind of welfare benefits case. It's about social housing, which is a form of welfare benefit, subsidised housing for people who need it. It's nothing to do with recruitment or promotion. And in my submission, the appellants are wrong to submit the case law that provides for a very restrictive approach to positive action in the context of recruitment and promotion applies across here. There's nothing to support it, nothing in Cresco which would begin to support it. So that in terms of proportionality and the proportionalities test as it applied in this case, the best guidance one can have, given that we're now considering it through an EU prism on the de bene esse presumption that we're within the race directive, as I understand it, or primarily, the best guidance, whilst I don't propose to take you there, is in Lumsden. It's page 2821. For your notes, I particularly draw your attention to 2843, paragraph 33. It's Lords Reed and Toulson. So paragraph 33 is the usual appropriate and necessary. kind of formulation which looks very similar to paragraph 65 of Cresco. And I also draw attention to paragraph 55, where this court gave guidance. In particular, one can get into a debate about how strict the two limbs are about being appropriate and necessary. And paragraph 55 contains relevant guidance that the test of being appropriate is not absolutely strict. It's rephrased by the CJAU on occasion as not inappropriate. And the formulation in relation to necessity given by this court is no less restrictive a measure would be equally effective. And that is not dissimilar from Lord Reed's quotation of Chief Justice Dixon in Oakes, and in particular his third test, whether a less intrusive measure could have been used without unacceptably compromising the achievement of the objective, and that is within the cases before you, Bank Mellor, paragraph 74-75 at 3622. So that is all I proposed to say orally, and I believe I've finished within time, unless you have any questions.
I think not. Thank you very much, Mr. Hutchings. Now, Mr. Wise, you have a right of reply.
Thank you, my lord, my lady. Can I start by making a few general points and then perhaps turn to some of the more detailed comments that my learned friends have made over the course of the last day. The first point derives from a point my Lord Reed made yesterday, but it was also touched on by both of my learned friends during their submissions, and that is the consideration of the difference in language in the Race Directive and that in the Equal Treatment Directive, in the derogations and positive action provisions in those directives that the court has already seen. What you will also note, my lords and my lady, is that the language of the derogation in Article 8 of the Race Directive is for all material terms the same as the language in Article 1414 of the EU Treaty, which is now 1574 of the EU Treaty. That's at EF 4566. And my learned friend Mr. Hutchings took you the court a few moments ago to the Briesh case and the way that they considered both the derogation, the relevant derogation, and Article 141 as it was at that time. And your lordships and your ladyship will have seen that they took exactly the same approach to the Article 1414 provision as they did to the differently worded Article 5 provision in the Race Directive, and Article 2.4 of the Equal Treatment Directive. I apologise. And so one must derive from that then that the court, the European Court, takes the same approach in respect of Article 2.4 of the Equal Treatment Directive, Article 41 now, Article 157.4 of the treaty, as it would do to Article 5 of the Race Directive. Now that's the analysis as the court has seen from Professor Fredman, who's a preeminent professor, an academic in that area. And so that is the probable approach that the court would take if it was put to having to decide a case on the derogation in the Race Directive. Now, of course, there isn't any case law directly on the case on Article 5 of the Race Directive. So we're having to be guided by what case law and interpretation the EU court has placed on similar similar statutory measures. Now, oh, I'm sorry, Lord Sales.
Yes, thank you, Mr. Wise. Isn't it just inherent in the proportionality analysis, as generally stated, that you have to identify a legitimate objective, and the proportionality analysis is fashioned with reference to what counts as that legitimate objective? And the reason I make that point is, might it not be said that there is actually, as my Lord Reid indicated yesterday, an important difference between Article 2.4 of the Equal Treatment Directive, which essentially declares the legitimate objective which can be pursued as promotion of equality of opportunity, yes, as opposed to Article 5 of the Race Directive, which talks about equality in practice. Now, if you have a different approach to what qualifies as a legitimate objective, isn't it inevitable as a matter of logic that the proportionality analysis will be different?
Well, the proportionality analysis will be different. If that's correct, my lord, then the question necessarily arises as to why the Court of Justice took a different approach in Brioche. Because if one looks at paragraphs 27 through to 32, EF 3222 and 3223, one sees that they took exactly the same approach. And so the word opportunity that appears in one and not the other of the derogations is plainly not deemed to have been material to the consideration of the permissibility of the measure in that case. So that rather we suggest that strongly supports our case. But the question then arises as to if there is any doubt, and we say there isn't any doubt, but of course we're assumed now that we're in the scope of EU law, and therefore it's the EU case law that is important. It's not the domestic case law. But if we accept then that we're in that case law, and the case law points in that particular direction, then that is the approach that the domestic court should take. The court could only take a contrary view, we would suggest, if it's so obvious as to leave no scope for any reasonable doubt. Now, we say there isn't any reasonable doubt. That's supported by Professor Redmond. There's no case law to the contrary. But if the court is nevertheless troubled by it, then the obligation must then be to make a reference to the ECJ. But we say that there's no need because it's clear and obvious. And that's the point we make on that. The case law all points we suggest in one direction. Now, my learned friend Mr. Grzyński said that the case law is only relevant with respect to Badek and Lomas. Well, in fact, those cases both support our case. Both are concerned with cases involving equality of opportunity measures. They both consider proportionality in that context. And critical to their conclusions in both cases is that neither measure was automatic and unconditional. And the court's seen the raft of cases where the European Court considered the proportionality of measures that weren't automatic and unconditional. But what we haven't had a focus on, and we would suggest no cogent response to from my learned friends, is the approach of the court where there is, as in the present case, an automatic and unconditional measure. Now, in opening, we said that the approach of the European Court to such cases is, firstly, as set out in Kalanka and Marshall, but more discreetly in the later case of Brioche, particularly at paragraphs 23 and 24, where they say effectively that an automatic and unconditional measure would by its nature be disproportionate. And there's been no response to that from the Macmillan Friends at all, albeit considerable focus on whether the proportionality measure, where there isn't an automatic and unconditional measure, there is a proportionality exercise. And so there has to be an in principle evaluation of whether the measure in question is firstly a measure that seeks equality of opportunity, or whether it seeks an actual result. Now we can test that by some of the examples Malone Friends have given to the court. Malone Friend, Mr. Hutchings, a few moments ago mentioned the Ward case that we have in the papers, and the decision of the Court of Appeal that the residence criteria of the local authority in that case was unlawfully discriminatory against Irish travellers. And he said that if the appellants are right in this case, then they wouldn't be able to do anything about it. But that's simply wrong, because all that was being contended for in that case was that class of people, that class of applicants for accommodation, being allowed the opportunity to go on the housing register and bid for properties. It's a classic example of equality of opportunity. Ditto the example that Malone Friend Mr. Brzezinski gave earlier today about the WI. Again, a classic example of equality of opportunity. And further to that, it's not just the conferring of a substantive benefit that is material in this context. What's particularly objectionable is the conference of a benefit in a blanket way, in a blanket policy. And all the relevant case law, we say, points in one direction, albeit that it isn't by reference to this particular paragraph of this particular directive. But there's nothing, no in principle reason why it shouldn't be. So that then deals with that principal point. The next point is the scope of the race directive. So if there be any misunderstanding about this, our case is that only Jewish people are eligible for Agedus's properties. The fact that there is an additional religious criteria is, we say, neither here nor there, because a non-Jewish person who observed the tenets of Orthodox Judaism would not be eligible under Agedus's policy. Agedus accepts, as we've seen from their case, their written case, that all recipients of their properties meet the matrilineal test for being Jewish. That necessarily follows from the JFS case, that is an ethnic criteria, which is a necessary but not determinative criterion for being eligible for properties from the Agedus Israel Housing Association. And that puts us full square, we say, within the race directive. My own friend, Mr. Brzezinski, said this morning, the examples that he did from, I think it was from the Equality and Human Rights Commission code, the Women's Institute and the Gypsy cases, we say were bad examples because they're examples of equality of opportunity and not impermissible positive discrimination. He said the consequences of the appellant submissions would be have surprising and extreme consequences. We say to the contrary, the consequences would be consistent with the current approach and understanding. And indeed, given that we've seen no other examples of bodies that have such an uncompromising policy giving exclusive benefits to one particular body, the consequences of the contrary consequences would be quite extreme, because they would permit those faith-based bodies and others of whatever faith or background to adopt similar policies to that of Agados, and give automatic consideration, automatic benefit, substantive benefit to members of their own community. That would be an extreme consequence, and we would suggest contrary to public policy. My learned friend Mr. Hutchings said that the Bangla Housing Association wouldn't be able to do what they do if we're correct, but that is simply not the case, because we know from the papers that what Bangla, the effect of what Bangla does, and we've got this at EF 882 in the annual report that was the most current at the time that these proceedings were before the lower courts. We see there the distribution of ethnic origin of their tenants. Now, this is a housing association working in East London, primarily directed to assisting, as this name suggests, the Bangladeshi, working within the Bangladeshi community. And as we see from EF 882, 43% of its tenants are of Bangladeshi ethnic origin, 17% European, 14% African, and 9% Caribbean. Now, whether that reflects precisely the ethnic composition of that part of East London, we're not sure. But one at least sees that is a not an unconditional approach to the allocation of their properties. And moreover, when one looks at their objects, which we've got at 891, we see that, save for the words in parenthesis in Agados's objects, the primary objects are in identical terms, the Bangla and the Agados Israel objects. And so we see, firstly, what do we derive from that? Firstly, we derive that Bangla wouldn't fall foul of the law as we say it should be interpreted. Secondly, we see that Bangla does indeed allocate its properties on not on an exclusive basis. And thirdly, we see the similarity of the objects. Similar considerations apply to the industrial dwellings society. So that also goes to the common law proportionality exercise, of course, with respect to the case that's made against us that that to allow non-OJC members to be able to have the opportunity to be allocated properties would somehow undermine their objects and the way in which they operate their charity. Not so. It certainly doesn't undermine the Bangla Housing Association, nor does it apparently undermine the Industrial Dwellings Association, and we see no other similar examples. Moving then back to Mr. Brzezinski's comments that he made this morning. In a number of respects, he mischaracterized our case. He said in his introductory comments that we were wrong to say that Agados doesn't allocate its housing on basis of need. We were very careful in our opening to say that Agados primarily allocates its housing on basis of need, and that was a carefully chosen phrase, and we say a correct one. My learned friend also went on to say, the court will recall, that my client had moved before these proceedings were issued. And so somehow the submission would appear to suggest that therefore Agados's policy wasn't in any way unlawfully discriminatory. But that, of course, ignores the fact that for some considerable time, my client and her son had lived in dangerous conditions where there was a risk of serious injury and even fatal injury to her. The fact that she'd brought judicial review proceedings, early judicial review proceedings and had been moved, we say is also neither here nor there. If she'd have had the opportunity to bid for Agatis's properties at an earlier stage, she may well not have been in that situation. And so it matters not to whether the policy is unlawful, whether my client had moved before these proceedings were launched. She was prejudiced by the operation of the policy. With respect to the case law my learned friend took the court to, given that we're in the context of EU law, it's plainly EU case law that it is material. But surprisingly, my learned friend Mr. Grudzinski made the submission, in effect, that the EU case law is all somehow irrelevant, and we should consider this EU point of law through the prism of domestic law, cases such as Ahmed, XC, Tijere, and so on. That, we should suggest, it simply can't be correct. The Ahmed case is a very different case than the present case, as your lordships and your ladyship will see from a very brief look at the facts. That was concerned with a rationality challenge to the allocation of properties within those groups of people who are statutorily obliged to be given reasonable preference in the allocation of social housing by local authorities under section 166A, what is now 166A of the Housing Act. Now, that is plainly a case where the courts will tread very carefully because, as the court made clear, moving one group of people out of one category of preference to another would upset the distribution of those resources. And that level of detail is plainly a matter for local discretion by the local judgment, sorry, by the local authority. We're in very different territory here with the blanket policy that we're considering. We're also, of course, in discrimination territory. And my learned friend Mr. Grudzinski took the court to Lady Hale's judgment starting at paragraph 15, omitting to take the court to the previous paragraph, paragraph 14, where she said that the analysis, I don't have the clear words in front of me at the moment, but it's words to the effect that the analysis that with respect to rationality wouldn't apply to a lawful challenge, for example, on the basis of discrimination, a case such as this. So what she had to say in that case, plainly not relevant to this discrimination case. Lord Newberger made comments to similar effect to paragraph 46 in his speech in the same judgment. So one has to be very cautious, and indeed about reading cases with very different context into this present context. My learned friend also said that to allocate properties to those outside the Orthodox Jewish community would, the phrase I noted that my learned friend said, would be to undermine Agatis's charitable objective. Now, when one looks at their charitable objective, it clearly doesn't say exclusively Orthodox Jews. It refers to Orthodox Jews, but it certainly isn't exclusively for Orthodox Jews. And it's impossible to see how any fair reading of Agatis's charitable objectives can be properly read as being undermined if they don't exclusively allocate all their properties to members of the OJC. Now, my learned friend then went on to say, but Mrs. Simmons says that, well, if they had more properties, then they might be able to allocate to non-members of the OJC. But on analysis, that argument simply doesn't hold water. It can't be lawful, we would suggest, for a public body or a body exercising a public function to exercise its functions in a unlawfully discriminatory manner in a discriminatory manner on the basis that at some future uncertain date it may well exercise its functions in a different way. That simply, we say, is an impermissible approach to basic principles of fairness and discrimination law. Mullane Friend also made the point with respect to the administrative burden that it may well place on Agadas. But as we know, the way in which housing allocation works in their area, and particularly Hackney, is that Hackney themselves do an assessment of the needs of the individual applicant for social housing. Hackney do that assessment. There's no additional burden there would be no additional burden on Agadas in any event. And in any event, Agadas on their own case say that they do an assessment of those who apply to them. But the primary point is that it couldn't be an undue burden, and furthermore, an administrative burden can't be an answer to what we say is unlawful discrimination. Another further point that Mullane Friend prayed in aid of was that equal treatment is by reference to classes of people rather than individuals. We say that again is a wrong analysis of the relevant law. That law is clarified in the Attorney General's opinion in the Brehesh case. And if I can, for the court's reference, give you the reference, it's EF 3215. Bright line rules were a significant part of Mullane Friend, Mr. Grzyński's submissions. We're all, of course, familiar with the operation of bright line rules, the reasons for them, and the necessity for any bright line rule to be rational at common law. And that is all accepted. But bright line rules have no application in this context. None of the relevant EU law that the court has been shown has any reference to bright line rules. The test is whether it is permissible positive action, i.e. providing equality of opportunity rather than a tangible substantive benefit. The approach is very different indeed, and it's not just the language; it's the concept of positive action vis-a-vis positive discrimination that we are concerned with here. Mullane Friend referred to on a number of occasions to the Equality and Human Rights Commission's code of practice, and the paragraphs he referred to were in general terms not objectionable, but they aren't comprehensive. And one, of course, the court, of course, isn't bound by what they say anyway. It's only a have regard duty, and having regard to that, one sees that guidance from the EHRC doesn't give guidance on this crucial issue distinction between equality of opportunity and impermissible unlawful discrimination. Mullane Friend, Mr. Grzyński also said in his submissions that we made the incorrect assertion that market conditions are relevant. Now, that's a mischaracterization of our case. Market conditions are plainly relevant to the condition of to the assessment of proportionality if one gets that far. But when it's been identified that the measure is unconditional and a blanket policy, market conditions are indeed irrelevant. Market conditions are, of course, referred to in some of the cases, such as where it becomes relevant, where it's deemed as a preliminary point, as we saw in particular in the Lomas case, that the measure is a permissible equality of opportunity measure rather than an impermissible, than falling on the wrong line of the divide between opportunity and discrimination in the sense of giving a tangible benefit. So that's the place of market conditions, which we say is entirely consistent with all the relevant case law. Neither of my learned friends have shown any case law to the contrary. My learned friend then relied on the recitals to the 4 directives that he took the court to and have been considered in this case. But of course, all those recitals do is to foreshadow the derogation articles permitting positive action that the court were then going on to consider. So those don't really take, those don't take us anywhere, save for reminding us that these are in the context of a presumption of equality and non-discrimination, and these are derogations from that principle that have to be strictly construed. Again, we've had no cogent answer to that point from either of my learned friends. We then get the new point about the public benefit test, parade in aid on Agadus's behalf, which is all very interesting, but we would suggest irrelevant in that it's apples and pears. We're considering here 2 quite different things. The public benefit test is by reference to the objects. We're concerned with we're not making a challenge to the objects of the charity. We're making a challenge here to the policy that flows, that is adopted by the charity, the policy and the practice indeed. In that context, the public benefit test is wholly irrelevant. The public benefit test that presumes the objects of this particular charity has got nothing to do with, and it indeed doesn't say, that the properties and the benefits will be given automatically to one section of the community. It is, we say with respect, therefore, a red herring. We've already dealt, I think, with the ethnicity point. So just bear with me one moment, my lords and my lady. I think I'm told by one of my juniors that I misspoke. I meant to say primarily on the basis of need, not primarily on the basis of need. Earlier, that was a slip of the tongue. Sorry, primarily on the basis of race or religion. I'm reminded. You'll just bear with me one moment. Look at one other point. Is this 628 or 6? Yes, I'm asked to remind the court of the comments of Lord Justice Mayors in granting permission to appeal. It's at EF 628. Where he says that in circumstances where no accommodation has been or is likely in the foreseeable future to be allocated to anyone who is not a member of the OJC, it is at least a realistic argument, etc. And then goes on to say that the policy will affect the families in similar need and cases may made in cases, in families in similar need and so forth. And that was the reason why Lord Justice Mayo has granted permission to appeal, and why this case has enduring importance and is properly before this court. In fact, I don't understand it's suggested that it isn't properly be before the court. So in summary, we say that our case can be taken essentially in three steps. That the case law shows that that a body can't confer substantive benefits directly. It can't have a totally blanket rule, and it certainly can't have a totally blanket rule conferring a substantive benefit. That's with respect to the third issue, of course. The Article 8 issue is, of course, a moot point. We've got nothing more to say about that. We would, however, make a couple of closing points with respect to remedy. And what my learned friend Mr. Grzyński said on that point. We say that firstly, it's in convention jurisprudence, it's perfectly possible to interpret the provision in question compatibly by reading proportionality into section 193(2)(b). That's entirely consistent with the approach of the House of Lords. There's the well-known speech of Lord Nichols in that the court will be aware of, but also we would invite the court to go back to the speech of Lord Steyne, which follows Lord Nichols' speech in the Guyden case, which you've got in the papers, a short speech of 2 or 3 pages, which sets out very clearly the strong and important interpretive obligation that derives from the HRA in convention cases. And with respect to EU law, my learned friend Mr. Grzyński says that it's not possible to read in the way that we suggest. Well, when one considers the judgment of Sir Andrew Morritt in the Vodafone 2 case that the court was taken to yesterday, it's patently clear that a reading in of the sort that we contend for is entirely possible in this case, and nothing's been shown apart from the general proposition that it would go against the grain to do so. Nothing has been shown to show why that is not the case. We say it's entirely possible and doesn't go against the grain. My lords, I see it's just turned 4 o'clock. I don't know if there's any other things, matters. My lord, Lord Sales.
Yes, Mr. Wise, since you're winding up, I just wanted to ask a question for clarification. I noticed that you haven't sought to reply on the Jiska Finance case. I've been back through your pleaded case in the courts below, your skeleton arguments, and your printed case for us. I haven't found any reference to indirect discrimination under the race directive. And I'm rather inferring from the fact that you haven't sought to reply on Jiska Finance that you've not sought to rely upon a case of indirect discrimination under the race directive. Is that right?
Your lordship's inference is entirely correct.
All right, that's very helpful. Thank you.
There don't seem to be any further questions for you, Mr. Wise.
But those then are my submissions, my lord.
Well, we're most grateful to all counsel for their assistance, not only those who've addressed us, but also those who've no doubt been working behind the scenes. This is an interesting and important case with implications that go well beyond the immediate parties to the case. We'll now take time to consider our decision. The court will adjourn.
Thank you.